Hi, this is Alan Gassman. You've made it to another Thursday, October 10th. It's 12:30 p.m., and we are here with America's #1 estate planner, the man who has done more for the estate and the estate tax planning industry than anyone else in the history of mankind, Jonathan Blattmachr. Jonathan, welcome.
Thank you, Alan. It's great for me to be here, and I appreciate everyone who's logged in taking a few minutes to listen to some of the things I have to say. And Alan, that was very complimentary, although I'm not sure everything you said was true.
It's all true, and I appreciate you being here, and I really appreciate how you make yourself available for not-for-profit organizations that give tax conferences, because you're a big attractor of people who want to see you at those conferences. And quite frankly, some of those conferences need help in attendance. So you've always been very generous with your time, very generous with your availability to speak on various topics, and it's really appreciated.
Well, Alan, as you know, I just love it. For me, it's not a job. It truly is an adventure. And I think that when we deal with a law, especially with respect to taxes, it's so complicated. It's so easy for people to be fooled or even scammed, that having, well-versed, professionals to guide clients is just a great thing we can all do.
Right. And for those of you on the call who don't know Jonathan, because you're not estate planners or lawyers, Jonathan is a very intellectual, very brilliant, and very prolific writer, speaker, and has been a practitioner in this area. So whenever we talk about big topics and big things that come up, somebody always says, well, what does Jonathan Blattmachr say? And then we wait for his article. So Jonathan, I've rolled the red carpet out. What are we going to talk about?
Well, Alan, I'm going to talk about 5 or 6 things depending upon our time, which may not come up every day. Some will, but maybe I'll take a slightly different angle. One is when you have a client approach you about forming a private foundation or a private trust company, I'd step back a little bit. Now, I've been involved with private trust companies my entire career. In fact, one of America's most prominent families took my advice and created its own trust company. But I warned them that what would happen is that there would be pressure from the family because of the cost of having a private trust company to change that so it wouldn't be so expensive for the family members. And indeed, that private trust company now takes any sort of clients who come in and have the requisite amount of wealth. And so that's something you need to consider. I've created a number of private trust companies, and often that was done to try to relocate the place where you had the trustee. For example, in California and in many states, if you have a trustee in that jurisdiction, you're subject to California income tax on undistributed income of a trust. California also has a special rule that even if you have a corporate trust company, you're still going to be subject to California income tax if the trust in fact is administered in California. One of the largest trusts in America came to me, and they were subject to tremendously high California income taxes, not quite as high today, because today California's income tax is 13.3%, and remember, until 2026, non-deductible by the trust. That's a huge price to pay.
Yeah.
So I formed a trust company under actually Nevada law then, but Nevada law on private trust companies was different. You could form just a regular corporation under Nevada law, and it could act as a trustee of a trust for a designated family or a designated trust, provided you didn't have the word trust in the name of the corporation. And that saved the family literally tens of millions of dollars each and every year. And that's a good reason to have it. Although, again, when your clients ask about a private trust company, you've got to warn them of 2 things. Number one, it's going to cost more money to have a private trust company than to hire an independent corporate fiduciary like J.P. Morgan or Bessemer or Peak Trust Company or whatever it may be. It's going to be much more expensive. Second, and this is just human nature, and this has happened with every one of the trust companies I've formed, the staff begins to want to expand because they realize that gives them more power, they become more important. And when you think about it, it's almost impossible to fire the trust company. So I would suggest when your clients come in and want a private trust company, ask them to take a second look and see whether or not you're better off hiring independent corporate fiduciaries or independent people. For example, as is well known, the Rockefeller family has a trust committee, and it's a very high-powered individuals. It's not a trust company per se, and that's something they should consider. The other one is where a client comes in and says, I want a private foundation. And I'm going to tell you that in most circumstances, unless there's a tremendous amount of wealth, the family may be better off going to a donor-advised fund. There are many, many great community foundations in the United States. I had the privilege at one time of being counsel to the two largest ones in America, New York Community Trust and New York Community Fund, and there are great ones. There are great ones in Cincinnati. There are great ones in Oklahoma, almost every area of the United States. And you can go to them and create a donor-advised fund. There are also some commercial people like Fidelity where you can do a donor-advised fund. Now, it's not identical to a private foundation insofar as you can't dictate what they'll do, but almost always the donor-advised fund will make whatever donations you want, and if there's enough money involved, they'll also get involved in some complicated transactions. The advantages of having a donor-advised fund as opposed to a private foundation are enormous. First, the income tax benefits when you make a donation are typically much better than if you make a donation to a private foundation. Second is you don't have to worry about those very complicated and onerous Chapter 42 rules which apply to private foundations. For example, a private foundation has to pay the equivalent of 1 or 2% basically income tax. They call it an excise tax, but it's basically an income tax. Donor-advised funds don't pay that. The third thing is you don't have to worry about acts of self-dealing. So you'll come across, if you have a private foundation at some time, you're going to have to call the lawyers in and ask, can we do this? I want to make a loan to my private foundation so it can do more, but can I make a loan to a private foundation, or how can that be done? Well, in some cases it can be done relatively safely, but you don't do your own brain surgery and you don't do your own tax planning when it comes to Chapter 42. Because under Chapter 42, those excise taxes are mean, and the one with respect to self-dealing, even if you have an opinion of counsel that is perfectly okay, you're still subject to the fine, which can be 200% of the amount involved. The other reason that you probably don't want a private foundation is you have to do special reporting. You have to do special reporting through the Attorney General of the state where the private foundation is. You're subject to special scrutiny. And as a consequence, if your client comes in, unless they've got a gajillion dollars, you really should talk to them about having a donor-advised fund. That's a much better thing. And here's a little hint. My wife and I, on December 30 of 2017, took the amount that we thought we would be giving away to charity over the next 8 years, from 2018 through 2025, when you couldn't deduct charitable contributions if you took the standard deduction, which was raised. We created a donor-advised fund, and it's worked out just great. And one of the nice things is you can make an anonymous donation if you want. So that's something to really consider about. The other thing that I've been spending a lot of time thinking about and talking to my dear friend Mitchell Gans is using the temporary high exemptions for estate, gift, and generation skipping transfer tax purposes. Right now, you have an estate, gift, and GST exemption of $11.4 million. It's going to go up to about $11.6 million beginning on January 1. It's a tremendous amount of property to transfer. And I would suggest you consider having it used by your clients and yourself for a couple of reasons. One, it is going to go down, and an exemption is almost always better off used early rather than late in the game. One reason is you not only get the assets out of your estate, but you also get the ability to get the growth and income out of your estate as well. So that's something to consider. The other thing is we don't know how the 2020 presidential election or House or Senate elections will go. But if you have a Democratic sweep, just like the Republicans had a Republican sweep in 2016, some of the Democrats have said that they really want to change the way the estate and gift tax rules work. For example, they're talking about putting in a $3.5 million estate tax exemption, but only $1 million gift tax exemption, which would be a really big deal. And it's basically now a use it or lose it idea. So you're either going to use the exemptions or you're not going to use the exemptions, and I think you want to consider using them now. One of the problems, of course, is other than Alan, who can afford to give away $11.4 million, or if you're married, $22.8 million now? Can you really walk away from that much money? Well, again, other than people in Alan's wealth category, most of us can't do that. And unfortunately, it appears that you might say, well, look, I know it's going to go down to $5 million adjusted for inflation in January 1, 2026. So I'll use half of the exemption now, and I'll have the other half to use later. You can't. The way the calculations work, it's almost certain you can't just do a partial use on a permanent basis. If you give away, for example, $5.7 million now and say, I'm going to preserve the other $5.7 million plus its growth, you can't do that beginning in 2026. You've either got to use it all or none. Well, again, who can afford to do that? There are some ways in which you can give away the property, but really get the benefit of it. One is if you're in a very, very good marital situation, you could create a trust for your spouse. Your spouse could have a power of appointment and exercise it back in trust for you at a later time. Another way is to create a so-called self-settled trust, one which you create or settle for yourself, and you're only a discretionary beneficiary. And if you create it in a jurisdiction where your creditors can't attach it, that will be a completed gift. Take a look at Revenue Ruling 76103, so you can make the gift complete. But if your creditors can get at those assets in the trust, then they're going to come back into your estate as though you never gave them away. So that's a problem. So how can I do that? Well, you can create your trust in a jurisdiction where your creditors can't get it. And if you take a look at Private Letter Ruling 2009-44002, Alan, you might, I don't know if you could put that up on the board, but 2009-44002, the IRS ruled, based upon Revenue Ruling 2004-64, that if you create a trust in a jurisdiction where you're able to create self-settled trust, the assets should be excluded from your estate. There's even a simpler and better way to do it, and in theory, this would work in any jurisdiction: Florida, California, New York, states that don't have really strong self-settled asset protection trust legislation. And that's through the creation of an idea that I wrote up with my dear friend Abby O'Connor and my best lawyer friend Mitchell Gans, a professor at Hofstra Law School and at NYU Masters in Tax Program, and we call it the Special Power of Appointment Trust, or SPAT, S-P-A-T. Here's how it works. I take $11.4 million and I put it in trust for my family. My wife, by the way, whom I will carefully define as the woman to whom I married at the time in question. By the way, you may not want to show that to your client's spouse. She or he might be offended, but that's the best thing to do, because there could be a divorce, there could be a death, and you can, if he or she remarries, now you've got someone to whom the property can be given, and she can expend it on the couple. But you create it for your family, not for yourself. In fact, you expressly provide that the trustee will never have any power, whether by decanting or otherwise, to distribute property back to the settlor. But you're going to name your best friend, or maybe your three best friends, giving them a collateral special power of appointment. Now, a collateral special power is one where the power holder has no beneficial interest in the trust. And that's a very long history in the common law for that. States have it. Don't worry. You can create a trust and say, my brother Doug or my cousin Barbara is given a special power of appointment, exercisable in a non-fiduciary capacity, to a class that includes yourself. For example, it might be the descendants of your mother, it might be the descendants of your grandmother, whatever you want. And believe it or not, you probably can retain a power to veto what the power holder wants to do. But you can go ahead and do that. Now, why isn't that problematic? Well, it gets back to the definition of what is a self-settled trust. Many states, like New York, basically have a statute which says a self-settled trust is void with respect to the settlor's creditors. And that was the universal rule until we started having self-settled trust jurisdictions in the United States, and there are now 19, with Indiana just coming online. So you can create one. But suppose you live in a state, or you get into an accident, or someone sues you in another state, can't they go to the judge and say, hey, Your Honor, under the law of this state, like New York, that's a self-settled trust, and we want to get the money out of that trust to pay our claim? Well, guess what? If you can't get a distribution in the discretion of the trustee, it's not a self-settled trust, because the definition of a self-settled trust, and you'll look to this at the Uniform Trust Law, you can take a look at the Restatement of Trust. A self-settled trust is one where the trustee has the power to make a discretionary or a mandatory distribution to the settlor. You won't have that. You're going to prohibit that. But someone can have a special power of appointment which could be exercised in favor of the settlor. So that's one of the ways, and perhaps the safest way to do it. Now, that's the rule in everywhere. I could create such a trust in New York, even though we have this rule under EPTL 7-3.1 that a self-settled trust is void with respect to the settlor's creditors. And we're going to prohibit distributions to the settlor by the trustee, which means it's not a self-settled trust, and that means it doesn't fall under that provision of New York law. And yet someone has a power of appointment. Now, everybody on the phone who has done much in the way of estate planning work has certainly done a number of trusts where you gave somebody a special power of appointment. And I don't think you necessarily said, by the way, this can never be exercised in favor of the grantor. But you never thought, oh my gosh, I'm putting these assets back into my client's estate because in theory, either now or in the future, some beneficiary excuse me, could appoint the property back to or for the benefit of the settlor. Well, again, we're going to do that. We're going to give somebody a power of appointment and make the class broad enough to include the settlor. So you can go ahead and do that. In fact, what you could do is actually decant the trust to expand the class to whom the power holder can do it. And again, this will be a collateral power of appointment exercisable in a non-fiduciary capacity. So the power holder is not a beneficiary, and the power holder can't appoint it to himself or herself, just in favor of a class which would include the settlor. So that's something that I really think you should consider. Now, again, you can do that in New York, you can do it in California, you can do it in any of the states which hasn't adopted self-settled trust legislation, but don't. Go to a state that has self-settled trust legislation as well. So if the creditor comes in and says, this is all phony baloney, I want you to ignore it, and so on and so forth, and beats on the table, you can say, look, Your Honor, we happen to be in a state, let's say it's Wyoming or Nevada or South Dakota or Alaska or New Hampshire or Ohio, which has self-settled trust legislation, and we'll have that apply. That's really an important thing to do. The other thing I would recommend is don't have a trustee or even a trust protector who is in a state that doesn't have self-settled trust legislation. You want to go that extra mile and really get it there. And that's something that you really want to consider. Really want to consider that for purposes of using the exemption and also just for general asset protection. People care about asset protection. It's a critical point when it comes to things like using your exemption and doing effective estate planning. It's also important for everyone your clients love. Every once in a while, I had a client came in and said, no, I want property to go to my kids outright. I trust them. They're bright. Well, there are two bad things that can happen with that. Number one, perhaps the child becomes incompetent. They have a stroke. They just get dementia of some kind. And I know now that I'm a senior citizen that senior citizens are more prone to being duped than perhaps younger people are. If you've got it in trust, they're going to be protected. And also when I say to the clients, okay, you're going to leave it to your kids. Where do you want your property to go when your kids die? And every one of them, of course, says, my grandkids. Well, guess what? If your daughter's husband dies, if your daughter dies, she may leave the inheritance she's gotten from you to her husband. If her husband remarries, he may leave it to his new wife or kids he has with his new wife. Don't do it. The answer always is put it all in trust. That's really very important. The other thing that I spend a lot more time in my practice today that I did in the past is look at investment returns. Investment returns are the key to good estate and financial planning. One of the things, however, is that you cannot exaggerate the power of compounding. You want to get things in there and compound, and the difference is absolutely enormous. Run an example where you're earning 6% a year for, say, 30 or 40 years or even 10 years, and then compare it to where you don't get compounding. It's enormous. For example, at 6% over a working lifetime, you will have 5 times more with compounding than if you don't get compounding. And that means you want to start planning and saving and earning as early as you possibly can. And one of the things that relates to is, of course, using a grantor trust, because when you have income earned inside a grantor trust, the trust grows income tax free. The grantor gets the income tax bill, and that means it's going to grow to a much larger position. Now, here's one thought to keep in mind. It's been proposed by the Treasury, and it's being proposed by the Democrats, that all grantor trusts will be includable in the grantor's estate at death. Now, my guess is that this will be prospective only. So one of the things you might want to do is to get your clients to create grantor trusts now and get them absolutely going, getting that power of compounding working. And with respect to the assets that have gone in there, with respect to completed gifts, it can continue to grow even if this legislation is adverse. Also keep in mind that there may be an extra bonus. A number of the Democratic contenders say that they want to have a wealth tax. Now, the U.S. Constitution says that the federal government can't impose a tax directly on property, and that probably was to prevent the government from imposing a tax on real estate, which is one of the ways that the states and local governments always were able to collect taxes. So, but now they're saying we want one on wealth. Well, they'll figure out a way. I mean, right now they have mark-to-market rules for income tax purposes. Even though there's no normal realization, they go ahead and they say that they can tax that, and they'll do it again. I still think there's any question, but that they will be able to impose a wealth tax, which, by the way, many states had a wealth tax. For example, Florida for decades had a so-called intangibles tax. Michigan had an intangibles tax. Pennsylvania had an intangibles tax. And some states or local governments still impose a tax on tangibles, for example, on your automobile. So don't think this is something new. It's just different at the federal level. But a lot of countries now have an annual wealth tax, and we may get one as well. So putting assets in trust now is critically important. How are you going to get it back? Well, again, self-settled trust or create one for your spouse are ways to go, or the so-called special power of appointment trust probably is a good idea. But the most important thing is to get assets going and growing. And another important thing is avoiding income tax. The difference between tax-free returns and taxable returns over time is enormous. For example, if you earn 10% on your money, and you have a 40% tax, so you're earning 6% net each year, and you have another 10% where you don't pay tax, over a working lifetime, you will have 10 times more property if you don't pay the income tax. I know that sounds ridiculous, but it is absolutely true. 10% tax-free versus 10% subject to a 40% tax or 6%, the difference over a working lifetime will be a 10-fold increase in the amount of wealth. I just tell you, it cannot be exaggerated, and getting your clients to start doing their planning now is extremely important. One of the things I've had a number of people, former clients of mine, call me about is possibly getting citizenship in another country. And the reason they do that is they're very worried about onerous wealth taxes being imposed upon them. Now, whether or not that happens, we don't know. But they say, I want to be able to freely go to another country, give up my U.S. citizenship. Yes, they may try to impose an exit tax, but I really want to do that. I really want to get out. Can a U.S. citizen get citizenship in another country? Yes, you can. Now, by the way, you can buy citizenship in some little countries like Nevis, St. Kitts. You can go ahead and by putting money in bank accounts down there, you can get it. That's not the kind of citizenship that I've been telling people they ought to get. They ought to get first-class citizenship. By the way, if you're Jewish, you can automatically demand Israeli citizenship, but Israel imposes a lot of tax. So my clients, former clients who are Jewish, have kind of rejected that. Perhaps there are two places where you may be better off. One is Ireland. If you invest enough money in Ireland and spend a certain amount of time there, you can become an Irish citizenship. Ireland is a first-class country. It's part of the EU, probably will remain part of the EU, which means you can go anywhere in the EU just because you have that Irish passport. And it does not subject you to Irish taxes. The United States and I think the Philippines are the only countries in the world which impose a tax on the basis of citizenship as opposed to residency. Another possibility is Canada, which is a country I just love. But you have to spend a considerable amount of time there in Canada. But your clients who are very wealthy and who are worried about wealth taxes or possible confiscation can consider that. The final thing I want to talk about is how artificial intelligence is going to affect our lives and our practices. I just spent 2 days lecturing with Mike Graham, with whom I write a computer program for lawyers, which uses a little bit of artificial intelligence, and a computer expert named Jeff Glickman. And I think the audience appreciated it, and I appreciated being able to do it. Because artificial intelligence, which is everywhere now, is going to become even more important and much more powerful because of a development that Jeff has made called artificial superintelligence. Now, most of you won't do this, but I urge you to go onto Google and look up artificial superintelligence. And down a little ways, you're going to find an article by a man named Brick that was published in the Harvard Science Review, where he explains that, well, let me tell you how it starts off. He says, Arthur Clarke, who was the author of 2001: A Space Odyssey, which many believe is the most significant movie ever made. It came out in 1966. 2001: A Space Odyssey was written by Arthur Clarke, and Arthur Clarke once observed that any sufficiently advanced technology is indistinguishable from magic. And if you think about it, if you go back 100 years or 200 years or 300 years, or maybe only 50 years, and you showed people who were alive then what we have today, they would think this is magic. This is absolutely magic. So yes, a sufficiently advanced technology is indistinguishable from magic. But as the author of the article in the Harvard Science Review mentions, we're now at the precipice of having something so great that it's not only indistinguishable from magic, it really will appear to be a deity here on Earth. And that's artificial superintelligence. And it's estimated that it will have an IQ of 30,000. And it will be able to do things in every area of human endeavor better than any of us have ever even dreamt about. It'll completely change our lives, and it's certainly going to change the lives of those of us who practice law. Now, law, I think, is probably one of the safest things you can be in because it's not just technical answers. A lot of it is emotion, but they now have emotional stacks that they put in computers to figure out how people are doing things, how they feel, and I'm told that these computer programs based upon emotion actually do better in interacting with human beings than a human being himself or herself does. Well, Alan, those are some of the things I wanted to talk about today. Give me some feedback.
That was fantastic, Jonathan. Lots of good thoughts. Tell us about Interactive Legal.
Well, Interactive Legal is the computer system that I write with Michael Graham, and it uses artificial intelligence in a limited way. For example, if you're unfamiliar, say, with a charitable lead trust, you haven't done many, and you might say, gee, is this an appropriate thing for this specific client to do? You can have a dialogue with the computer, and you answer the questions, and it will analyze it, and it will prepare a memorandum, and it will tell you whether or not that's an appropriate strategy for that particular client. There's nothing else out in the market like it. The other thing it does is that it automatically drafts documents, not by word processing, but something called document assembly, where you answer questions and you don't pick the language, the computer picks it for you. And it's built to try to reduce the possibility of errors or mistakes or inconsistencies. So that's available, and we also have one that does work for elder law. And I'm very, very proud of the work we've done, and I can tell you that a couple of our customers have told me they'd sooner give up their secretaries than give up interactive legal.
No, you've done a great job for the whole profession with interactive legal, no doubt. And tell us just a little bit about Peak Trust Company, then I know you have to go.
Well, Peak Trust Company it used to be called Alaska Trust Company, was a trust company actually formed by the Aleut Corporation, which is a corporation formed by the Congress for the people who populate the Aleutian chain of islands, known as Aleuts. So the Aleut Corporation, after certain laws that I had recommended to the Alaska legislature were adopted, and that was the first, for example, self-settled trust legislation, and the second state to have decanting, they went ahead and called me and asked me to help form a trust company, which eventually my brother, who had run trust departments in Alaska, began to run, and he is the chairman of that. In fact, his son is now the president of it, and I actually use it. So I also work for them from time to time, but I just think it's a great institution, a very low cost provider, and I don't believe I have ever had any client of mine who used Peak walk away and go to someone else for whatever that is.
No, they're fantastic, especially Brandon Santula there. They do a great job. Well, Jonathan, I know you've got another appointment. I can't thank you enough for myself and everyone who's attended. We really appreciate all you're doing, and I hope you keep doing it and doing it.
Thanks, Alan. Goodbye, everyone.
Goodbye, and may the rest of your day be billable.